Welcome, everyone. Thank you so much for joining us this afternoon. This is our part 2 of our special education webinar series here at Let's Go Learn. This is the most common IEP legal errors and how to avoid them. My name is Lily Rivas, and I will be moderating the session. I'm a senior customer success specialist here at Let's Go Learn. And without further ado, let me introduce some key people. Oh, actually, before we get started, I'd like to remind you that there is a little panel on the right-hand side of your screen with an orange arrow. If at any point the panel appears in the middle of your screen, you can click on the arrow to bring it far away, or you can actually click it to let it go forward. You also have the ability to ask questions as we go. We will be taking questions at the end, but if you think of something, you can go ahead and type it into a chat box. I would like to remind you, however, that sometimes our speakers will be answering questions as they're going, so you can maybe pause a minute before you ask your question. I'm going to go ahead and turn off my camera so I can start introducing some key people. All right, so first and foremost, let me introduce Dr. Mitchell Yell. He's a professor, a legal author, and board member of the CEC. He's an expert, as you can see by this slide. His expertise is quite expansive. I'd also like to introduce to you Dr. Kurt Hulett, who's our National Director here at Let's Go Learn for Special Ed Services. He's been an author, he's a veteran educator, and he's a lifelong advocate for children with disabilities. I'm going to go ahead and turn this over in 1 second to Dr. Hulett, but just a brief agenda. We're covering the introductions. We will get into some legal discussions with Dr. Yell. We'll take some Q&A. And if you'd like to hang on, we are going to highlight some of our features here at Let's Go Learn. Dr. Hulett.
Thank you so much, Ms. Lily. I appreciate you. Super excited to be here today with you. And LGL, Let's Go Learn, is sponsoring this learning series because what we do at Let's Go Learn is two primary things. We want to really have an impact on creating and supporting districts as they move forward to provide educationally meaningful opportunities for their special education kiddos, as well as the legal compliance component. And we basically provide diagnostic assessment, digital instruction. We also provide specific special education reporting that allows you to basically generate present levels as well as IEP goals and short-term objectives. We support the progress monitoring of those goals and objectives. And then we also provide extensive professional development to special education districts around the country. And to tell you a little bit about myself, I've been using Dr. Yell's books since graduate school. And my role with Let's Go Learn is to inform the special education development of products and to ensure that we're supporting special educators around the country as much as possible. And I myself, as well as the company, have been strongly influenced by Dr. Yell's work and his continued work in this field, because his two areas of expertise have really been around the meaningful educational experience for children, as well as the legal compliance surrounding the implementation of these programs. So we couldn't be more excited to sponsor this learning series with Dr. Yell and to support Dr. Yell in his work. And we couldn't be more grateful for his many decades of service to special education. And at the end, as Lily mentioned, we're going to be doing a quick product demo. And the importance of that is basically to demonstrate to you how we're taking the principles taught by Dr. Yell and implementing them in a way that supports school districts. So would love for you to hang on and kind of see what we're doing. It'll be quick and I think super meaningful to you. But to no avail, let's jump in and start our conversation with Dr. Yell. If I can do a quick summary of last time we met, we really looked at the elements of quality IEP documents and planning, as well as the legal aspects of those documents. And, and just to summarize, Dr. Yell, and please feel free to jump in, it seemed to really fall around three key elements that teachers tend to have a large effect on and impact on. And those are creating present levels, ensuring that we have baselines in those present levels, ensuring that in those present levels, we also address how the disability affects the child in the regular education curriculum, and then essentially linking the data from the present levels to the creation of annual goals. And then Dr. Yell also went into great detail about the importance of progress monitoring measurable annual goals and short-term objectives. He tied it into Andrew F. In the takeaway from the 2017 Supreme Court case. And so what I took away was that there are three huge elements that educators really have to focus on: the present level, annual goals, and progress monitoring. That's not to say that's the only components of the IEP, but three critical areas that educators control. And today, what we're going to be looking at is a little bit of the other side of that, which is looking at some of the errors that are commonly made by districts. And we're looking at these things so we can also discuss how to avoid them and what strategies you can implement to avoid these potential errors. So Dr. Yell, thank you so much for being with us. And if you just want to jump right in and start talking about, kind of the common IEP errors you see from around the country and what we can do to avoid them. Oh, you're on mute.
Yeah, thank you very much. I'm going to turn on mute a little bit because given this is a live webinar, of course, immediately upon starting this webinar, some lawn people pulled up across the street, and so hopefully it won't be too noisy for you. Yeah, and what I wanted to start with, Kurt, is just some background that yeah, I have been doing legal issues for a long time, been very interested in it. I've also was a due process hearing officer in South Carolina for probably 10 years, and now I'm what's called a state review officer. We have a two-tiered system here where due process hearings, which arise when, of course, parents and school district personnel are in disagreement on some aspect of the parent's child's education, and they request a due process hearing. And of course, there's mediation and there's different things they go through. But in terms of a due process hearing, that in my state is held in a local school district or the local educational agency, and the decision is made by a hearing officer there. If the decision is appealed, unlike Texas, I believe, where a parent can go straight to court, federal or state court. In South Carolina, we have what's called the second tier, where the first appeal would go to the state review officer. So I wanted to give that background in that I've done hearings and state reviews, and so that's where I get a lot of this information regarding the kind of mistakes that school districts make. Also, I generally don't do this, but in the last year or so, I've done some expert witness in due process hearings, and there's information in those situations too that kind of inform me about the different types of errors that school districts make. And so what I thought I'd do is follow up with our discussion last week with just some of these errors that often school districts run afoul of the law. Some are more simple than others, some are more difficult, but they're very important because oftentimes they lead to school district losses. And one other thing I wanted to say before I get started is we in special education comprise about 10 to 12% of the public school population. Yet our population accounts for probably 80 to 90% of all the litigation in education. And of that huge amount of litigation, most of it, probably 95%, is what we call FAPE litigation, or it's about free appropriate public education. And almost always, and certainly in the hearings I've been in, that boils down to what was done at the IEP table. What happened when the parents and the school districts got together, and what kind of mistakes were made that led to a denial of FAPE. So that's basically what I wanted to talk about today.
Good deal. Well, can we just jump right on into some of those most common ones that you see, and what are the ones that the districts can avoid pretty easily?
Yes, absolutely. Let's do that. I think these errors are, some of them are simple, some of them are a little more complex, but I think school districts with proper knowledge and training of personnel can avoid these sorts of errors. And what I've kind of done is force these into an unlucky 13. So I really have 13 errors that I wanted to talk about that school districts can avoid. But before I talk about the actual errors, I just want to go back a little bit to some review from our last time together when we talked about court cases, specifically 2 cases that were heard on free appropriate public education. One of them was Board of Education of the Henrik Hudson School District v. Rowley, which was way back in 1982. In fact, that was the first special ed case ever heard by the U.S. Supreme Court. And it was on FAPE. It was on what exactly is a free appropriate public education. And then the other case we talked about last week was Andrew F. v. Douglas County School District, which was heard by the U.S. Supreme Court in 2017. That was also a FAPE case. And these 2 bookend cases heard by the Supreme Court are, in my opinion, probably the most important cases, and certainly very important in that they really talk to us about the different issues that school districts run up against that can lead to a denial of FAPE. And the first thing I wanted to say about the Rowley decision in 1982 is they talked about, the Supreme Court talked about the importance of the procedures in the law, these procedures that we all know of, which are very common, are not just mere formality. In the words of the court, they have to be followed, because as the court said in 1982, adequate compliance with the procedures can assure much of, if not all of, what Congress wished in the way of substantive content of the IEP. Well, I would say, no, we now know that is not true. Nonetheless, we still have to follow those procedures. So a number of the errors that I'm going to talk about are really procedural sorts of errors. Now, secondly, the other bookend case was the Andrew F. v. Douglas County School District, which is the next slide, in which, and I won't go into this case, but we talked about it a little bit. If we go back 1 slide, the Andrew F. case really involved the substantive issue. And the substantive issue, or what is it in an IEP that we can do to provide an education that confers meaningful educational benefit, enables the child to make progress appropriate in light of his or her circumstances. So that really has to do with the substantive issues that I'm going to be talking about today. And the Supreme Court also noted that an IEP must enable a child to make progress. After all, the essential function of an IEP is to set out a plan for pursuing academic and functional advancement. So in essence, these 2 Supreme Court cases in the next slide really developed a 2-part test that school districts need to follow in terms of developing an IEP for a student that confers a FAPE. And the first part of the test is really from the Rowley decision. And that is, has the school district complied with the procedures set forth in the law or set forth in the act? And the second part of the test is the following: is the individualized education program reasonably calculated to enable the student to make progress appropriate in light of his or her circumstances? So every time I have a FAPE case, or I go to a hearing that is a FAPE case is involved, these 2 questions are going to be asked by the hearing officer. This is how they make their decision. This is how a judge will make their decision in a FAPE case. First, they're going to look at the procedures. Did the school district follow the procedures? Secondly, they're going to look at the content of the IEP. Did the IEP enable a student to make progress? So those two things are really important to remember, because virtually all the errors are going to be in these two general categories. Procedural, that's kind of the dimension of free appropriate public education that involves questions about when and how we've accomplished our special ed programming, and that includes tasks like identifying students, conducting our evaluations, developing RFPs, and the timelines that federal government have and states may have. But the second part is the substantive, and that was the part that was addressed in Andrew. And the substantive dimension focuses really on how adequate is the IEP? Is the IEP going to likely to enable a child to make progress? So in other words, this dimension focuses on the adequacy of the IEP with respect to its likely or actual results. So that more or less involves the what or the content of an IEP.
So let me ask you, Dr. Yell, just looking at it historically, is it fair to say, because my memory of Raleigh is that it set a very low bar for what the districts had to do as far as demonstrating progress or demonstrating benefit. And then when Andrew came in and put the term progress in there, now all of a sudden, as of 2017, we now have a higher bar of what school districts have to present, produce, and demonstrate. And so really, with these two cases, with Andrew F., it really has changed the expectation for school districts and what they deliver to children. Is that accurate?
Oh, absolutely. That is very accurate, very, very well stated. Back in 1982, we have to remember when this case was first heard, the regulations, the idea had really just taken effect, and there was not a lot to go on. And if you look at the definition of the FAPE in the idea, it essentially says FAPE is whatever the IEP team says it is. And so what they back in 1982 said, well, Congress had all these different procedures they put into the law. That's how they must have intended that the IEP would be honored or a child would receive a FAPE, is if school district just meets the procedures. But cases after the Rowley decision had shown no, that was not the issue. Procedurally, there's no problem. It's easy to figure out if a school follows procedures or not. You just look at what the school did and kind of match it to what the law says and decide if they followed the procedures. But when Andrew came along, they said, well, this law is more than just about procedures. It's about the substance, what exactly is being provided to youngsters. And it definitely raised the bar, because the original Rowley decision essentially said it means the child is to benefit. They didn't say how much. And some courts are saying, well, just de minimis or trivial benefits enough. And other courts are saying, no, it has to be meaningful benefit. So the Supreme Court kind of got rid of the benefit and substituted the term progress, meaning forward movement. That to meet the substantive standard, we have to show that we have either developed an IEP in which a child has actually made progress, or that we've developed an IEP that is very likely to confer progress.
So let me ask you a question, Dr. Yell. From my standpoint as a practitioner, one of the things I've observed over the years that seems to run parallel with the advent of some technologies is that I've seen goals become more broad-based, not always individualized, sometimes difficult to measure. And I've noticed PLAFs that don't always have baselines. And pre-Andrew F., I don't think there was a lot of concern about this, because as long as you didn't show damage, you didn't really have to demonstrate the quality of the IEP document. However, it seems now if a parent's attorney or advocate can prove that your goals aren't measurable, that they're broad-based for all kids or just drop-down goals, that they're not measurable, they're not meaningful, there's no baseline in the PLAF, that can put the district at significant risk now. Is that accurate, or is that just my perception?
No, I think that's very accurate, because the emphasis is really on the substantive nature, or the content of the IEP does enable the child to make progress. There are still procedural errors that can be could cause a school district to lose. But in the IDEA reauthorization of 2004, called the Individuals with Disabilities Education Improvement Act, Congress actually said that due process hearing officers and judges really are supposed to make their decisions based on the substance of the IEP. Is a child making progress in light of their circumstances? So yes, it's very much what we talked about last week in terms of present levels serving as a baseline, goals being actually measured, and then really measuring them and keeping data. Those are all very important, and I think do elevate the FAPE standard.
And I think that, you know, you're noting an enormous shift that has really occurred fairly recently. The other thing you referenced that I think is important to note is the difference between procedural and substantive. When I went through undergraduate and graduate, it was pre-2004. And I remember being trained that you've got to dot every I, cross every T, and if you don't, you're going to be in a sling. And the notion was that if you make a procedural error, you're in pretty significant trouble. Whereas the shift seems to be now, if you forget something minor that does not have a significant impact, that in and of itself will not become a FAPE issue necessarily. That there really does have to be a significant impact, that by not doing the procedural approach that's in the law, it has to have what you're calling a substantive impact. Can you talk a little bit about that, so that schools are not always in fear of not dotting every I perfectly or crossing every T?
You know, that's a nice way to put it, Kurt, because there are, I mean, we should follow all procedures, but there are some procedural errors that, well, that's not that big a deal. There are some procedural errors that are really, really bad procedural errors, and those are the types of errors that really get school districts in trouble. And I'm just going to talk about a few different errors here for a second, and please interrupt me if you want. There's certain procedural errors that school districts make outside of the IEP process. And when I talk about the IEP process, I mean the team getting together with the parents and the school-based personnel and writing the IEP. That is the IEP process. But there's certain things that school districts do outside of this process regarding the special education evaluation and things of that nature can also get them in trouble. One of them is failing to fulfill child find duties, because school districts have an affirmative duty to go out and find children with disabilities who need special education services. They can't wait for a parent to call them or some event to happen. They have to be affirmatively looking for these children. Those are called the child find duties of IDEA. We have to take those very seriously, because when school districts blow that, or they don't fulfill their child find duties, it's very likely they will lose in a hearing or a court. And as I said, it means that schools have an affirmative duty to find children with disabilities who need special ed. And there's a standard that's been developed by the courts called the KOSK standards, K-O-S-K. That stands for new or reasonably should have known. If a court is convinced that a school district knew that a child was a child with a disability and needed special ed and didn't provide it, or didn't refer the child, or they should have known that a child had a disability, that is a failure to fulfill child find duties. So if you just think of that acronym, KOSK, K-O-S-C-H, again, knew or should have known, you have to really be, looking out for these children. So that's one type of error. If a school district makes an error there, it's very likely they will lose. Another type of error has to do with placements, because placement, although it's technically not part of the IEP process, most IEP teams decide on a student's placement, and that's absolutely fine. But when they decide, they make the decision based on elements other than a child's individual needs, that can be a violation of the idea, and a very serious violation. Let me give you a couple examples. Let's say a school district decides that, well, although we have children with autism, we're going to do away with our special program for children with autism and educate everyone in a special school. We're not going to do it in the regular school anymore. So they'd segregate the children. They make that decision. That is an illegal decision, because you can't make a carte blanche decision for every child with a disability. You have to make it on an individual basis. Similarly, if a school says, well, we have these special ed classes in our school, but we're going to include everyone, regardless of their needs, they're going to be in the general ed classroom 100% of the day, that would be as illegal as saying that we're going to put all students in a special school, because you're not considering a child's individual needs. And there's a reason that Congress in 1975 included the continuum of alternative placements, because they wanted to have every school district to have these different options for meeting a child's needs in the placement that is the least restrictive, but also appropriate. A third mistake outside of the IEP process that school districts often make is called what attorneys call shoehorning. That's when a team determines the placement before the program. That can be a pretty significant error. Why? Because if you determine placement before the program, clearly you're really not taking into account the child's needs, because that is determined in the program. So if you do the placement before the program, that's kind of putting the cart before the horse. We can't do that. We have to do the what, or the program, before we do the where, or the placement.
So let me ask you a couple of questions, Dr. Yale, and beginning with the LRE issue. So in my experience, a lot of school districts, and it makes sense to me why they do this and why this happens, but a lot of kids fall into categories based on disabling conditions. So let's say you have a Down syndrome child. In a lot of districts, those kids become somewhat slated for certain programs. So if you have a life skills class and 9 out of 10 kids with Down syndrome prior to your child have gone into the life skills program, then the district will often write that IEP prior to the IEP meeting with a placement of life skills for that child. Now, I don't think their intent is to predetermine, but from their experience, based on IQ and other factors, they often, get very used to placing children based on disability in certain categories. How can school districts avoid falling into this approach?
Well, and that's a good point. And of course, there's nothing at all a problem with putting a child in a life skills class, but you have to do it based on the child's needs. So you have to talk about his needs, his or her needs. And that may be that we decide as an IEP team that that's going to be part of the child's program. Absolutely fine. It's just that we shouldn't be doing placement before we talk about the child's needs.
Well, on that point, one of the things that I've always recommended, and I see a lot of districts will make this error, is that they fill out the entire IEP form prior to the IEP meeting. Then when the parent comes in, essentially there's already this draft that has been fully completed. And I've always recommended, don't fill out every section, don't fill out the LRE until you get there. Do you have recommendations for procedurally what districts can do to prevent the perception of predetermination?
Well, and that's a really important question, because as well, I was going to talk about this later too, but predetermination is almost a certain loser if a hearing officer believes the school has predetermined placement or programming decision. So you know, I think in a situation like that, it's just vital that, I mean, I was a teacher for 12 years, and in the area of emotional behavioral disorders in Minnesota, and many times, of course, we would talk about the program, we'd write a kind of a draft. The important issue there is that is only a draft, and whatever you've discussed beforehand, which is okay, must not be, you don't go into the IEP with a IEP finished, fait accompli, and just say, sign it, because that's predetermination. So what you have to do is, you certainly can have meetings and you certainly can talk about issues, but you just don't make any final decisions until the IEP meeting is held. And I would also say to avoid things like statements like, well, we're going to place little Jimmy in this setting. We can talk about it, but we know we're going to. Sending an email like that could be the death knell for a school district. So you want to make sure you really are not predetermining. You know, you may have ideas, and that's fine, but go to the IEP with an open mind, discuss all the issues, make the decisions then, and school districts will be fine.
What about also requesting input and or doing interviews prior to the IEP meeting, so you're sure to get parent input on record prior to even coming to the IEP meeting?
Yeah, that's absolutely fine. You can have meetings. One of my favorite decisions is, I think it was out of South Dakota. Parents had sued a school district because they had meetings beforehand. Well, there's nothing wrong with that, as long as they don't finalize decisions. And what the school district, or what the court wrote in its opinion, is that the school district must come to the IEP table with an open mind, but that doesn't mean they have to come to the IEP table with a blank mind. In other words, you can meet, you can discuss, just don't finalize.
So that seems to be a precarious situation, I think, for school districts to navigate, this idea between predetermination versus preparation. The district cannot write a full IEP at the IEP meeting because it would just take too long, but they want to be prepared because that's what school districts do, but they don't want to appear predetermined. So it seems to me that this is just a really tough area for school districts to navigate.
It is, it absolutely is. But from my experience as a teacher, it's virtually impossible to, if we went to an IEP meeting with nothing written in the IEP, that would just take an exorbitantly long period of time. So, you know, I'd have some goals written down and the need statement, some of the present levels, and that's fine as long as that is an open discussion in all those areas to which the parent can contribute. And school district personnel have to seriously consider what the parent is saying and actually encourage the parent to make suggestions or you know, different observations. But just again, school districts, I think, get a little too worried about that. They can have meetings, they just can't make decisions until they get to the IEP team meeting.
So last webinar, you talked about the quality elements of an IEP that educators versus, say, diagnosticians or school psychs tend to have control over, which of course is, you know, the PLAF, the goals, and progress monitoring. Can you talk a little bit about, as far as the development of those three things and areas that all should be linked together, can you talk about the errors you see that can lead to FAPE violations when it comes to a PLAF, an annual goal, or progress monitoring, or the lack thereof?
Yeah, absolutely. In terms of the IEP, the one thing I usually tell folks that I work with is that you want to make certain your IEP is internally consistent. If you have needs that you identify in the present levels statements, a need must have a service to address that need. And in most cases, it's going to have a goal to address that need also. And the Congress in the regulations and comments to the regulations have often talked about this importance of the alignment between the present levels, the goals, and the services that a school district offers. That's extremely important. Again, if you have needs identified and they're not addressed in the rest of the IEP, you probably have an illegal IEP. In fact, the last case that I heard as a state review officer involved IEPs for a child that clearly in the present level statement, there were math needs. As I looked at the rest of the IEP, math was not addressed in goals. It was not addressed in services. They had an internally inconsistent IEP, and it was illegal. I mean, I found in favor of the parents in this particular case because the IEP did not meet the requirements that the idea says that they need to be internally consistent.
So relative to these three areas and talking about internal consistency, another area I see, and I think it falls under your number 9 here, failing to implement the IEP as written. One of the issues I quite often see is when I request for the progress monitoring reports, the goal might say, Johnny in 4 out of 5 attempts will achieve 80% on reading comprehension passage questions. And then when I ask, if they said in 4 out of 5 attempts, they don't have 5 attempts, or they're not tracking and measuring as they said in the IEP. And so I'll see these very flowery goals, but then there's no documentation of the implementation as written. Can you talk a little bit about that failing to implement the IEP as written from that regard?
Well, once the IEP is developed, and this is kind of it really is a procedural and a substantive error. I just put it under the procedural part. And what I meant by that is really, you have your IEP developed. Maybe it's a wonderfully, procedurally, the school district has done everything correctly. Maybe substantively, it's a good document. All the needs are addressed. There's measurable goals. But if that good document is not implemented as written, that can be a fatal error for a school district. And that means, for instance, if you just have services you don't offer, that could be an error. Or if there are goals that are not measured, that can also be an error. So.
No, that's powerful. And let me ask you, we're going to move into questions here in a little bit, but I want to ask you about this issue because I think we need to make some improvement in this area. When you look at IDEA and the way it was developed, and the schools come in with many members, all of which they're highly educated, master's degrees and beyond, and often it's not unusual to have 10 to 15 people from the district on one side of the table and one parent on the other, often mom. And I don't think it was ever the intention, but it can set up a very intimidating environment for the parent, which can also limit input. And the parents also are rarely as educated as the district representatives there because that's what they do for a living. So can you talk a little bit about, because I know it's so critical in IDEA, about providing meaningful parental involvement and what it looks like when you don't?
Yes.
I think you're on mute. Yeah.
Yeah, that's a very important point. And in the previous slides where I did have some common procedural errors, that of course was one of the main ones. And when Congress in 2004 reauthorized the idea, they said that one of the elements of the law was that due process hearing officers have to make decisions based on the procedural errors only when they affect the child's education or deny the parent meaningful involvement in the development of the program. That is, if a hearing officer or a judge is convinced the parents were not involved in a meaningful way, that could be fatal to a school district. Well, the question is then, how do you involve them? One of the things many school districts I've worked with do is they have someone who acts as a parent, almost a parent, well, a parent advocate, where they meet with them and tell them what's going to be, often a counselor, meet with them, tell them what's expected of the IEP meeting, that we're going to do goals, that we're going to talk about your child's needs, and prepare them in such a way that they have time to think about what are some good things I could bring up in the meeting. Because as you say, it often is a very intimidating setting. So if they're thinking about goals beforehand, that can be a good way to get them involved. And we as teachers and LEA reps have to involve the parents, make certain that we're listening to them. Ask if they're not talking a lot, ask for their opinion. And just make certain that they are involved to the greatest extent you can.
A couple other quick things I'd like to react to really quick, Dr. Yell, is your number 12 and 13 here. And these are just powerful. Failing to link assessment goals and programming, which you referenced earlier. One of the big errors I see time and time again is that we often have multiple people developing an IEP, and it's often very fragmented. And we're not looking at the linkages between these critical elements. And again, so if you have a deficit, what is the goal? What is the programming? And how are you going to progress monitor that in a meaningful way? And where's the baseline? We don't tie these together. And if I could make a recommendation to the districts, it would be to provide overall conceptual training to your educators about how to align and link the entire document together so that it makes sense, it's sequential, and that it's practical in nature, and that you can find the answers and the relevant components. The other thing is you have here failing to monitor student progress toward goals and make instructional changes. And there are two things, you referenced Andrew F. and progress monitoring, which has taken a whole nother look now since Andrew F. And I often don't see where the goals are really being progress monitored or that they have documentation of it. And then the other thing is I will see in the first 9 weeks of school a goal mastered, and the school never goes back to adjust that goal, which they wait to the end of that IEP cycle to even address it. And that would seem like a potential major violation if you're not adjusting your intervention or goal or approach, and it's already been mastered.
And that's, I want to make a couple points. Your points are so important, Kurt. One is this failing to link the assessment, the needs, the goals, the programming, very important. How do we train people to do that? Barbara Bateman, who we both know of, back in 1992, wrote a book in which she said she suggested training teachers using what she called the non-form IEP. That too often we look at an IEP with all these different things we have to fill out, and we really miss the essential elements. The essential elements are really four things. What are the students' unique needs? How can we address those needs? Where do we expect, if the child receives services, they will be in 1 year's time, and how are we going to monitor progress? And she said, just have people, train people to write those four questions and answer them, and that's an IEP non-form. So by doing that, I believe we are doing exactly what you say, and we would be preparing teachers really to understand the essence of the IEP is in this internal consistency between the needs and the goals and the services and how we monitor progress. Now, another thing, and I think this is extraordinarily important, especially with the Andrew F decision, is what you say about monitoring progress, because in the IEP, we not only have to write the goals, but we have to say how we're going to measure students' progress toward those goals. And I know you've seen, and I've seen too many times, maybe goals that are measurable, but there's no indication they were ever measured, or the data was never reacted to. That is so important, because let me tell you, in the hearings I've been in, that's always a question. Show me your data. How do you know the child made progress? Or, how do you know this IEP is calculated to enable the child to make progress? So If we're going to have measurable goals, you have to have the data to show. A few years ago, I was at a conference in Omaha, Nebraska on special education law, and Kathleen Mayfitt, who is a recently retired attorney, and you know of her too, in the state, and this was 2 years before the Andrew F. decision, made a statement in the presentation that I asked her about, and I said, do you mind if I quote you on this? And she said, absolutely not. She said, when I have a school district with a FAPE case, there's going to be, and I'm going to be defending him in a due process hearing or maybe in court, the first thing I do is I go to the teacher and say, let me see your data on the student's progress. And if the teacher doesn't have any data, I consider telling the school district, you might want to give up on this one, settle it, because you may not win. And a good attorney is going to go right after that. So, and the best part about this is it's not just that it's an error, but we know from research by some very impressive people in the field that teachers that collect data and react to it have much greater achievement on the part of their students.
Well, sage advice, Dr. Yell. I wish we had several more hours for this conversation, but let's go ahead and jump into some questions and see what our listeners today might be asking relative to their everyday experience in the school districts. So why don't we hop over to that, and we'll move from there.
Sounds good.
Let's see, is that Lily or Alicia? Are you guys going to be getting and jumping onto some of those questions?
I do have a question for you already, but if anybody, I just want to let everyone know, if you do have questions, please go ahead and enter those into the sidebar. There's an area for questions, and we'll go ahead and get those asked. So the first question that we have is, when considering student placement for the initial placement, how does the new draft rule apply?
The new draft rule?
I think the new, like the Andrew F. I could be wrong. They can clarify.
Well, there was a really good document put out by the U.S. Department of Education in 2017, right after the Andrew decision. And if you go to Google and put U.S. Department of Education, Andrew F., you'll probably, I think that's the first or second thing that'll come up. It was a question and answer document. And one of the things they said about placement, because Andrew F. really didn't address placement, but there was a question in there, how did Andrew F., what does that mean for placement? And basically they said some of the things Kurt and I have been talking about. Placement has to be individualized. You can't make placement decisions before you actually decide what a child's needs are and address those needs. And also another thing, and another important point that I find school districts often get confused about is the continuum of alternative placements. And they're confused in thinking that the resource room for an hour a day or so is more restrictive. According to the Department of Education, using a resource room an hour a day for reading or for whatever special ed help a child needs is actually a supplementary aid and service and is not more restrictive. The only time it's more restrictive is if you spend perhaps the majority of a day in a special class. That is a little more restrictive. But Kurt was referring to a life skills class, 1 hour a day. That's not more restrictive. According to the Department of Education, again, that is a supplementary service to try and maintain the child in the general ed setting.
Very
Great,
interesting.
Thank you.
Do we have additional questions, Alicia?
Yes, we do. So this question is, what are your thoughts on a school district requiring an IEP team to have higher level at any IEP where a more restrictive placement may be considered for a student? So their district is moving to be more inclusive.
Mm-hmm. So I'm not sure could you repeat that question?
Yeah, sure. So the question's asking that if there's a higher requiring a district requiring that if there's a more restrictive placement, that they need to have a higher level IEP meeting. Since the goal is to be more inclusive, if it's more restrictive, having a different kind of meeting.
Well, I don't know if you really need to have a different kind of meeting, because Congress said that one of the elements of an IEP when a child is in a more restrictive setting like a special school, that you have to essentially justify that. Why you have to include an explanation of why the child is not being educated with their non-disabled peers. That's not necessary, of course, if the child is just in a resource room, but if they're in a very restrictive setting, like a special school, that has to be justified. But it's essentially the same IEP team that's doing this, making this decision.
Oh, okay, there actually is a clarification there. They wanted to know having a higher level administrator there.
Yeah, and so Dr. Yell, I was going to say, I think what this is when they have their regular IEP team, and instead of having a district representative that can truly approve resources at the district level, they might have a school administrator that's serving as a district rep. And so when they want these higher level services or more restrictive, then they actually get the appropriate district representative to the meeting. My concern would be that the way the law is written, they should have that district rep at the meeting the first time. You shouldn't have to have a second meeting to have the appropriate personnel.
Yeah, I think they were clarifying that they meant initially, just when they said higher level, they meant a higher level administrator.
Well, of course, the LEA representative really on the IEP team must be able to commit school district resources. I would say, in meetings where this may be a problem, if the school district wants to begin the process with, say, a district representative as the LEA rep, that would be fine. But that should be done right at the beginning of the process, like Kurt said.
The one recommendation I would make, Dr. Yellen, you tell me if I'm wrong, but I would not recommend at an initial IEP meeting when a certain service is asked for the district to indicate that they need a higher level administrator. They're going to have to do another meeting. What I might recommend is, it seems reasonable for a district to ask for a continuation to collect more data or do more research. But if you indicate you have to get a higher level member, you've just indicated you didn't have all of the appropriate members at that initial meeting. Is that accurate or possible?
Yeah, that's very accurate. And of course, one of the things, that I put in among the procedural errors is not having an appropriately fielded IEP team, not having all the people necessary to be there, or having an LEA rep who's really doesn't meet the requirements. So that it's very important.
Yeah, so they added a little bit more detail saying that there's always the LEA there, but the district is the one that wants a higher level person there because of the push for inclusion. So it feels like the team feels like they aren't trusted to make the decisions. And it's harder, making it harder for teams to determine a more restrictive placement.
I tell you, Dr. Yell, it sounds like the district's treading in some careful waters there, or some troubled waters potentially if they take that approach.
Yeah, possibly. I would just want to make certain that the LEA rep that you have from the beginning is able to make that decision. I mean, when you look back at the law, who is required? An LEA rep, the general ed teacher, special ed teacher, the parent, and someone who can interpret the instructional implications of the evaluation. Probably, I always say the entire IEP team is equal, but the LEA rep and the parents are a little more equal than everyone else. So they're very important. It's really important that that person be included on the team right away. I would say I would agree with Kurt that to say something like, well, we really can't make that decision right now until we have someone here, that would not be a good practice.
So let's go ahead and take this opportunity to wrap up real quick. And what I'd like to do, because we've spent so much time focused on this at Let's Go Learn, is I'd like for us to jump into this quick demo, but really to demonstrate how at Let's Go Learn we're taking the principles that Dr. Yell is referencing and teaching and applying them to our solutions at Let's Go Learn. So I don't know if it's either you or Alicia or Lily that's going to walk us through it, but why don't we hop into the demo now?
Awesome.
Absolutely.
Yes, it is Lily. And then Alicia will take over in a minute. So yeah, so talking a little bit about our platform here at Let's Go Learn, we do want to indicate some highlights. So first and foremost, our assessment and instruction are standards-based. We provide a comprehensive diagnostic that will provide you with granular data. So when you're really talking about the child find, really taking the time to test all of your students to then identify the students with the greatest gaps that might need that extra attention. So this is really important. A lot of our school districts use us for that screening type of process. The granular data also will lead to helping identify every single student's zone of proximal development in multiple areas at one time. Our educators are able to really quickly identify student present levels, which is the goal here. And then also, because we're providing present levels, you will also be able to find those quick instructional goals that will be unique to each student. And we also offer a progress monitoring tool that will allow educators to track growth throughout the school year, which again, these are things that are super important when speaking about special ed implementations. We provide an adaptive diagnostic platform, assessing multiple skills at one time in both reading and in math. As you can see, in math, we're actually assessing 44 different subtests for foundational math. So super important to really find those zone and proximal development in those areas. I'm going to go ahead and turn the screen over to Alicia.
Thank you so much. All right, so I'm going to just hop in. Let's see. I'm going to hop into, Lily, can you make me the presenter? All right, there we go. Okay, so real quick, I just want to go over our platform and just how it really helps with those last four. I mean, of course, child find, as Lily mentioned, but with those last four, those last four questions about finding, let's see, can you see my screen, Lily?
Yes, Alicia.
Okay, just want to make sure. All right, so those last four questions, which were about identifying, students' unique needs, writing those measurable goals, and identifying a method to measure the student progress, then linking the assessment, the goals, and the programming all together, and then monitoring student progress. All of those things can be done in our system rather quickly, in a way that allows a fluid process throughout the year or years. So we start with, a broad, I'm going to use math as my example, a really broad assessment. You can assess all the students and then sort, the students, look for inconsistencies for students that are struggling. You can look in each of the areas, like we mentioned, 44 different subtests, kind of targeting, where are students struggling? And I can see that, I have a student struggling in algebraic thinking. This is a student that is in 7th grade, but their scores are at the kindergarten, 3rd grade level. And so this is a student that I might, identify. And then from here, I can actually go into our special ed report. So we have a special education report that's purpose is to help find those present levels. So the first step is finding the present level. So I can
And Alicia,
algebra.
If you don't mind, if I can jump in real quick.
Absolutely.
So basically, the way we design this is if you look at the top right-hand corner where you have the total scores, the intent of that is for the educator to be able to copy and paste very quickly these scores into the present level. What this ensures is that you immediately have baselines in your present level of performance so that you can ensure that when you write your annual goals, that they're linked to the baseline that's in the actual present level. And when we look at this, we can look at any one of these, and we have, algebra, and that's at 2.87, I guess, or 6.7.
2.867, yeah.
Okay, and so let's come down here, and you've already clicked on algebra. We can look at present level, and what it's going to give us is the present level of those areas focused in on algebra, and it puts it in the form of goal language. So it's going to give you what they can do right now, the grade level, and then it's going to give you the standard that they're working on, the state standard of the actual level they're working on, and the standard of their actual grade level. So now if we want to do goals, what we can do is go to instructional skills to display. We click on that, and then what it's going to do is it's going to give us our goals relative to the baseline. So now, again, we're at like 2.67. So now all of these areas, relationships, expressions, equations, graphing, algebraic reasoning, now we're going to have goals that we can select that are linked to the baseline. And as Dr. Yell talked about, reasonably ambitious goals and being able to demonstrate progress on those reasonably ambitious goals, this is how we help you do that. We give you the baseline that's in the present level, then we give you all of the goals you will ever need, and you can select which ambitious goal you want. If you wanted a year's growth, a year and a half, 2 years, 2.5 years, you decide what you think can be achieved in a year. Now, if you also want short-term objectives to build up to that annual goal, we have several sub-goals that can also be put in there to add up to that final annual goal. So in this report, you have your present level data, you have your annual goals, and then one of the things we're going to talk about next is progress monitoring, and we're going to show you how you can actually progress monitor each annual goal and how it will automatically go into your data set and into your system.
Exactly. So looking at this, we're looking at algebraic thinking. So we can come in back to that student and look at their progress as we assess. So there's a couple of options. We have the full diagnostic, but we also have within our system, our test queue allows for students to be assigned very specific sections. So we could assess a subtest, for example, if we're looking at relationships, we could just assess the relationships, or we could go more detailed and look, within relationships and look for, or if we're looking at equations, we could assess, solving one-step linear equations, solving inequalities, very specific skills that we are looking at, and making sure that those students are hitting those goals. And then once we've made those, we've assessed those goals, we can see the progress in our system where we're looking at, we have a specific progress monitoring option, and I'm looking specifically at algebraic thinking. So I can see that this student was assessed in expressions and problem solving already. So I can track that progress. I can go ahead and chart that, and I can see in expressions and problem solving, if that was a goal, I can see the progress from first grade level to an end of second grade level. So that allows you to track that very specific progress and assess those specific goals. All right, we have a lot more, but yeah.
So Dr. Yell has spoken at length about the importance of progress monitoring and demonstrating progress. Now, Dr. Yell, I don't believe anywhere, whether it's the Andrew F. case in the justices or IDA, does it say how much growth. What's critical is that you demonstrate growth in general. Is that accurate?
Absolutely, yeah. Don't think of the IEP as a guarantee of success. It's a guarantee that we are, as educators, are making good faith efforts in collecting data and trying to ensure that the child does make progress. So what I'm looking at now, if I saw this as a hearing officer, that a school was collecting data and using it in this way, I mean, it's a slam dunk. This is really what the idea intends, I believe, what Andrew F. intends.
Well, the other thing I think about, Dr. Yell, is too, it's not just 1 year. You know, if a state agency goes back and looks at multiple years, it can be a challenge for schools to provide the documentation, especially if their teacher-made quizzes and tests that they're using to progress monitor, whereas systems like this have the data in a repository that the district can always access. And so it's a much easier, I think, safer way. It's also valid and reliable. Whereas, as you've mentioned, you know, teachers are not test developers, so they're not always reliable, nor are they always valid in the progress monitoring phase.
And we do have years of data on each student as they go through the, you know, the data follows the student.
Yeah, you know, Andrew F. did say at one point that hearing officers and judges can expect a cogent, responsive explanation for why your program is enabling a child to make progress appropriately in their circumstances. This right in front of us here is a perfect explanation. If you have this kind of data and you're using it, school district is doing all they can do, is certainly meeting the spirit and the letter of Andrew.
So before we log off here, one of the things I'd like to say to especially our district representatives, is that both Let's Go Learn, myself and our team, provide a great deal of support for school districts, not only in the way of our products, but also in broad-based training of special educators, teachers, administrators in special education compliance and practice, as well as Dr. Yell is one of the finest trainers in the field. So if you find yourself needing some support, wanting guidance on setting up not only an educationally meaningful, but also legally compliant special ed approach that's going to kind of keep you not only doing what's right for children, but also keep you out of hot water, please reach out to me, or certainly reach out to Dr. Yell. And I just want to thank everybody for being on today and being with us. Let me just ask real quick, we're fortunate to have our CEO on with us today, Mr. Richard Capone. And Richard, do you have any final thoughts you'd like to share with our listeners today?
No, I just wanted to just say that thank you for attending, and we're real excited to have Dr. Yell on. We really enjoy being able to provide everyone with real tangible information to help you. We know that it's very difficult to run special education departments. And so just want to thank you for attending. And you see from the information on the screen, we do have a demo next week, and we also have 2 more special ed webinars coming up. Thank you.
Thank you so much, guys. And thank you for your support, Richard and Dr. Yell. Thank you for all your leadership and continued guidance for the field as a whole.
Thank you.
Bye-bye, everyone.
Take care, everybody.